Catbalogan Holdings.
Yes, Mr. Brody.
May it please the court. I appear for the appellant company.
Yes.
And my learned friend, Miss Bowes, King's Counsel, appears for the respondent company.
Yes.
It will be apparent from the front page of the judgment being appealed, as well as from the conclusion, the name at the conclusion of the appellant's skeleton argument, that I am entirely new to this case. So, whilst Miss Bowes has been involved in the case from the outset and appeared for the respondent at trial, I did not appear below, and I did not draft the skeleton argument on the basis of which permission was granted. I naturally, therefore, I'm afraid, approach this appeal from a slightly different perspective, and for this reason will place more emphasis in this hearing on certain arguments that appear in the appellant's skeleton argument than they seem to have in that document itself, and it would follow I will place less emphasis on others. I do not propose, my lords, in my oral submissions to address the court on the terms of the intercreditor agreement or the meaning of the words cooperate fully in paragraph 5A of the additional agreement, or the interrelationship between the various paragraphs of the additional agreement, or any matters of that sort. There are, my lords, two reasons for this. First, the written submissions of the appellant on these technical issues are clearly set out in the skeleton argument, and I would not wish to waste the court's time by simply repeating them orally.
Right. So they are still part of your case, but you're content to rest on the written argument.
Yes, I will obviously take the court to one in particular, but otherwise I'm resting on the arguments as set out in the skeleton. And the second reason why I'm doing this, and it's the more important of the two, is that in my submission, the resolution of this appeal can be more efficiently and justly achieved, actually without reliance upon those which I do not draw the court's attention specifically to. In other words, and for reasons I will in due course explain, it is unnecessary for the court to get entangled in the weeds of the various contractual agreements in this case to reach the correct conclusion on the appeal. In essence, my lords, I have 3 points that I should like to make. And subject to the extent of my interactions with the court, I would expect to conclude my submissions within about half an hour, maybe less.
Right.
My first and primary submission is that paragraph 5D of the additional agreement, properly understood, did not prohibit the commencement of proceedings concerning steps taken by the bondholders or their agents. Now, especially in light of the constitution of this particular court, I do not think your lordships would be assisted by a recitation of the principles generally to be applied in the interpretation of contracts. In any event, those principles were agreed at trial and they were agreed on appeal. And the position is set out at paragraphs 49 to 54 of the judgment of Divider 6.
Yeah.
I wonder whether I might take the court to the final paragraph.
In the judgment?
In the judgment, which is at page 83 of the bundle. Core bundle. And so paragraph 54, Mr Justice Fancourt says this: the principle is summarised in a decision of Andrew Burrows, Queen's Counsel, as he then was, sitting as a Deputy High Court Judge in the Federal Republic of Nigeria and JP Morgan Chase Bank, which was approved by Lord Legate, quotes, applying the modern approach, the force of what was the contra proferentum rule is embraced by recognising that a party is unlikely to have agreed to give up a valuable right that it would otherwise have had without clear words.
Yes.
And as Lord Justice Bick put it in the Stochnier case at paragraph 23, quotes, the more valuable the right, the clearer the language will need to be, end quotes.
Yes.
So, for example, clear words will generally be needed before a court will conclude that the agreement excludes a party's liability for its own negligence. Now, in this context, namely the context of the value of the rights which it is said have been waived in this case, and which Mr Justice Fancourt held had been waived. And I appreciate the ambit of the grounds of appeal here, so I understand the limits of what I'm about to take your lordships to. In this context, I should like to make two observations about what this case resembles, but actually isn't. This is going to take a little time, I'm afraid, because these resemblances reflect precisely how valuable the court should regard the right to litigate, which the respondent contends Mr Justice Fancourt found has been contractually waived. First, this case resembles, but isn't, an ordinary application for an anti-suit injunction. There is a resemblance, of course, because the effect of the order, which forms the subject matter of this appeal, is that the appellant company is forbidden from pursuing a claim it has filed in the Paris court. The distinction between this case and an orthodox application for an anti-suit injunction is that there is no alternative tribunal to which the appellant can go to seek protection against illegality. As the court knows full well, the standard application for an anti-suit injunction will seek an order preventing the defendant from pursuing a claim in another jurisdiction. And the basis of such an application is, ordinarily, that the relevant contract has a provision requiring that any dispute should be resolved in, say, the courts of England and Wales, or by arbitration. And accordingly, an anti-suit injunction does not prohibit access to a court or arbitral tribunal. Rather, it simply dictates which court or arbitral tribunal should have jurisdiction. But in this case, the effect of the order of Mr Justice Fancourt is that the appellant company cannot seek protection against illegality on the part of the bondholders and their agents from any court or any arbitral tribunal in any jurisdiction anywhere on the face of this planet. That, in my submission, is an extraordinary position. During the course of my preparation for this case, I had a few hours looking at Thomas Raphael, King's Counsel's book on the anti-suit injunction. And I was looking for a case which had a factual matrix similar to this. And there simply wasn't one. There is, however, a section on cases in which the English court had declined to issue, there's a whole line of these cases, declined to issue an anti-suit injunction, notwithstanding that the contract in question had a choice of jurisdiction clause, because for various practical reasons, it was not realistic for the defendant to litigate in that jurisdiction. And on that basis, the English court concluded that an anti-suit injunction that would forbid the defendant from litigating anywhere other than in that jurisdiction would be non-compliant with Article 6.
Non-compliant with?
Article 6, the right to go to court, essentially, and right to a fair trial once you get to court. And so that's how valuable the right that the appellant is said to have waived is. It's fundamental. My second observation about what this case resembles, but isn't, concerns a matter to which Mr. Craig referred, my predecessor, in the final sentence of paragraph 9 of the appellant's skeleton argument. That's tab 2, page 23. What he's describing here is the common law principle of legality. It's effectively the common law equivalent of the first sentence of Article 6. Namely, the principle that persons should have access to the courts. And what Mr. Craig says here is, however, in construing the terms of the additional agreement as excluding or preventing the appellant from challenging in any court, including the courts the parties have previously designated for this purpose, any enforcement step or action taken by the agent or the respondent, whether lawful or unlawful, the judge failed to have due regard to this principle, given that the right of access to the courts has long been recognised as a fundamental constitutional right, inherent in the rule of law. See Lord Reed in the Unison case, to which I'll take your lordship shortly. It is submitted that a term of a contract abrogating that right must admit of no other meaning. And that is not the case as regards either Clause 5A or 5B of the additional agreement.
I think you would add all 5D.
I would, yes. And what's more, I think B is a typo. If I wouldn't add it, I'd replace it. Now, I'm going to deal with the submission that he makes here about it must admit of no other meaning, because that's an issue between the parties. But before I do that, I'd like to say something about the principle of legality. In the context of the Unison case, to which I'm about to take the court, and similar cases, what the court is addressing is legislation rather than commercial agreements.
Yes.
And so in the Unison case, the issue arose out of court fees, but there are others. For example, the court will probably be familiar with judicial review ouster provisions, which the courts are generally anxious to ensure don't violate the principle of legality. I wonder whether you could have a very quick look at the Unison case,
yes,
which is at Divider 3 of the authorities manual. Now, As the court will probably know, this was a challenge to the decision of the Lord Chancellor made by subsidiary legislation to impose fees on claimants who wish to commence proceedings in the Employment Tribunal or appeal to the Employment Appeal Tribunal. The matter ascended the judicial hierarchy to the Supreme Court, which decided the imposition of the requirement to pay these fees violated the principle of legality.
Yes.
Could you please start at paragraph 66, which I believe to be at internal page bundle page 167.
Yeah.
So what Lord Reed says here is, under the heading the constitutional right of access to the courts. The constitutional right of access to the courts is inherent in the rule of law. The importance of the rule of law is not always understood.
You needn't read this aloud, Mr. Bradley. Just tell us what you want.
66 and 67.
Yes.
And then jumping 2 pages, there's a fairly long sideline from paragraph 74 to, I believe, 85. May I take it that that has been or will be read, or should I sit down to give the court the opportunity to do it?
Well, if there are particular parts you want to draw attention to, give us a few minutes just to read those paragraphs. Yes.
Obliged. So returning, in fact, before that, so my ultimate submission in relation to the principle of legality is that what we have is an essentially constitutional rule enshrined in the common law that requires that persons should have access to the courts where they can seek protection against illegality. Returning to the skeleton argument of Mr. Craig.
In the case of a contract, the parties are, for practical purposes, making the law for themselves,
I
aren't they?
appreciate that. But this is the reason why ultimately I added the third issue, which hasn't been agreed by those representing the respondents, and which didn't form part of the grounds for the appeal.
No.
I recognise that. But there comes a point, let's assume that I'm wrong. Let's assume for the moment that which I don't accept, that the contract did effectively waive access to the courts. What should the court then do about it? Looking at Article 6 and looking at the principle of legality, in the exercise of its discretion, it is very difficult to see how the court could comply with Article 6 or the principle of legality by issuing an injunction. Because what it effectively it then does is prevent the litigant concerned from having any opportunity to litigate against illegality, for protection against illegality, in any court or tribunal anywhere. And that on the face of it is constitutionally impermissible, as well as being...
But that amounts to a submission. You cannot waive your right of access to the court. And the jurisprudence of the Strasbourg court is that that's not so. You can.
You can, but whether or not the court should enforce it in this way is another matter.
If you can validly waive your right of access to the court by contract, why should the court not enforce it by injunction?
Because ordinarily, the point of the court should be extraordinarily reluctant to do it, given how significant the right is. And in this case, in my submission, if Mr Justice Fancourt was correct in his interpretation of this particular contract, and as the Lordship knows, that's not my position, what the court here should have done is to issue a declaration to that effect, and then the bondholders could have taken that to the Paris court and said, look, on the face of this finding from the English court, these proceedings may well be abusive. What do you think? And it should have left the matter in the hands of the Paris court rather than taking the decision here to prevent that litigation. And the Paris court would then, in the way in which the courts do here, when there is an argument that one of the parties to litigation is behaving in an abusive manner, weigh the level of the abuse against the general circumstances of the case, which would obviously take into account the merits.
But I mean, suppose that I agree to sell shares to you at fair market value.
Yes.
That's it. We don't say anything more about that. And we disagree about fair market value. You might well be able to go to the court and say, look, please determine the fair market value. Or we could say, I'll sell shares to you at fair market value, and if we have a dispute, we'll go to arbitration about it. In which case, if we disagree, you go to arbitration. Or I might say, I'll sell the shares to you at fair market value to be determined by an expert. No right to go to court.
No, but that's of course an example that's given by my learned friend in her skeleton argument. I was about to touch on that, but those are mechanisms for the resolution of a dispute. They are not the prevention of the resolution of a dispute.
Can I suggest another example and see what you say about this? Quite a common way to resolve disputes between parties is for a party to give what's called a covenant not to sue. different from a release. Party A says, I shall not sue you in respect of X, Y, and Z. Courts very often enforce such covenants. That is a complete, that's an agreement completely not to go to court.
I understand.
Now, what do you say about that example? It doesn't. There's no fallback adjudication. It just is what it is.
Of course.
And those agreements are clearly regarded as valid and enforceable.
I understand that. That's a slightly different scenario from the one we have here. Let us take your lordship's situation and assume it's in England. Somebody then sues, and the court would then look at the agreement that had been reached not to sue and would probably enforce it. It might not. It might look at it wouldn't shut out the possibility of litigating it. It would look at all the circumstances and then reach a conclusion as to whether or not the agreement not to sue should be enforced. And in 99.9% of cases, it would come to the conclusion that that agreement should be enforced. But we've got a different situation here where there's litigation in Paris. And what my submission is that the ultimate decision as to whether or not that should be pursued is a decision that should be taken by the Paris court rather than here.
But on just expanding on my example, it says, the contract says, I agree that I will not sue you anywhere in the world. That contract itself is governed by English law.
That's this case, essentially. On the.
I'm asking, how does that tie in with your principle of legality, access to justice, and so on? In the example I've given, A has said, I'll not sue you anywhere in the world, and then goes off to a court in Paris and sues. The settlement agreement is governed by English law. B comes to the English court and says, I want to enforce this covenant. Now there wouldn't be any question there, would there, of principles of legality or access to justice?
No, there would be. If somebody does sue, you have to look at whether or not what they have agreed ought to be enforced against them by injunction, and you ought to look at the merits of what they're saying, and you balance the two against each other. If they are saying, for one reason or another, we've got a really strong claim. I mean, my learned friend actually relies on fraud, for example. She says in her skeleton argument that we would be able to pursue in Paris if what we were alleging was fraud. So in those circumstances, the court would have to carry out a balancing exercise. Now, it's obviously difficult if the party seeking to enforce the apparent waiver is doing so in one court, and the litigation which it's seeking to restrict is in another court.
So is this argument that even if the judge was right in his interpretation of the disputed clauses, he was wrong to grant an injunction? Because if that is so, it is not a ground of appeal.
I appreciate that. Which is why I'm only relying upon these two principles as an illustration of the weight that should be given to what we're waiving. I'm familiar with the ambit of the ground. I think I've already dealt with my learned friend's submission about. In fact, no, I'm going to take your lordship's to it anyway. Paragraph 8 of her submission, which is at divider 3, page 43. What she says here is, on appeal, the appellant proposes a novel principle that a term of a contract abrogating a party's right of access to the courts must admit of no other meaning. There is no authority cited for such a proposition. This is despite the fact that agreements that restrict or prevent a party's access to the courts are not uncommon, such as settlement agreements, including those preventing a party from bringing unknown and oblique or future claims, expert determination clauses, and limitation or exclusion clauses. I've already observed that those examples appear on the face of it to be mechanisms for the resolution of a dispute rather than what we've got here. But if we need an authority at all, one has to look at the litany of authorities that one can see in unison. Essentially, the right is so valuable that it's difficult to see that it could ever be waived, save in circumstances where the words concerned bear no possible alternative.
What Unison says is it must be clear words. Does it go any further?
No, I wouldn't say there's any difference between the two. If you've got clear words, they don't admit of any alternative.
Is the principle you rely on the one that you took us to in the judgment,
Yes.
which was the passage from Mr Burrows?
Yes,
So that's the principle.
that's the principle for the interpretation of contracts. Yes, you weigh how.
That's 54 of the judgment.
Yes, you weigh how valuable what is said to be waived is when assessing whether or not there has actually been waiver. And the Article 6 arguments and the principle of legality arguments I've just advanced essentially enable that process to be undertaken. And when you do that, I would say either no other alternative interpretation, which is the words of Mr Craig, or clear words, I think is the words in unison. But I wouldn't say there's a distinction between the two.
Yeah, I mean in Unison, that paragraph 76, Lord Reed says that examples can be found of judicial recognition of the constitutional right of unimpeded access and so forth, which can only be curtailed by clear statutory enactment.
Yes.
And then at 79, he says the court's approach in these cases was to ask itself whether the impediment or hindrance had been clearly authorised by primary legislation. Well, that's the test.
Yes,
Is it
clarity.
clear?
Yeah. Now, possibly later than we expected, I wonder whether I might now take the court to the relevant contractual provisions.
Yes.
Now, paragraph 5D of the additional agreement may be found in its native form at divider 11, page 138.
Yep.
I noticed that my half an hour was typically optimistic. I'm sorry. Paragraph 5 begins, subject to the terms of the standstill agreement, the company parties, and dropping down to D, which is, in my submission, the pivotal, if not the first provision, agree and acknowledge that no company party shall contest or seek to contest or otherwise prevent the validity of or exercised by the agent of its rights under any finance document, including any security document, including without limitation, the approach to the appointment of the expert under the Lux share pledge and oblique or the Lux receivables pledge set out in paragraph C above, and the company parties hereby irrevocably release any rights or claims they may have now or in the future in this regard. Was what the company party was agreeing here was not to contest or seek to contest or otherwise prevent the validity of or exercise by the agent of, and the following words are pivotal in this appeal, its rights under any finance document. Its rights under any finance document. Now, our core submission on this is conveniently set out at paragraph 25 of Mr. Craig's skeleton argument, divided to page 31. What he says here is clause 5D contains concessions with respect to the cooperation that the appellant agrees to give with respect to enforcement action that the agent / the respondent wishes to take. Critical to its interpretation is the meaning of, in quotes, the agent's rights, end quotes. The relevant rights are those under any finance document. In other words, they are the rights therein prescribed. No further or additional rights are given by reason of this clause. Consequently, if the right to do a particular thing or take a particular course of action does not arise under a finance document, i.e. it is not granted by any finance document, it is submitted that, contrary to the finding of the judge, there is no prohibition against the appellant or Poseidon, / the company, contesting it. The agent is not given greater powers than it otherwise has under any finance document by virtue of this provision. The agreed prohibition is as regards the exercise by the agent of rights or powers that it is given under the finance documents. If the agent does not have a particular right or power under a finance document, it does not have it under clause 5D of the additional agreement. Accordingly, if, for example, a particular course of action is unlawful or not permitted by the terms of a finance document, clause 5D of the additional agreement does not have the effect that it prohibits the defendant from challenging it in the agreed jurisdiction for the determination of disputes. To put it shortly, my lords, if the appellant wishes to complain in the agreed jurisdiction, which in this case is the Paris court, that the conduct of the bondholders and their agents is unlawful and does not fall within the rights provided to them under any finance document, paragraph 5 of the additional agreement does not, on its face, debar the appellant from seeking the protection of the Paris court against that illegality. One doesn't need to apply a significant level of strictness to the interpretation of that provision to reach that conclusion. It doesn't require close textual analysis, cryptanalysis, Talmudic interpretation. It's simply the natural meaning of paragraph 5D. And of course, the position of the respondent is that one has to interpret the additional agreement in conjunction with the other agreements and in light of the commercial realities of the situation. And that's not controversial. But the conclusion reached by Mr Justice Fancourt on that issue was, in my submission, clearly wrong. I wonder whether we might go to paragraph 74 of the judgment, where the learned judge sets out his conclusion. It's at divided 6, page 86.
I mean, the most likely controversy, to use a neutral word, is whether the agent has the right claimed.
Exactly. And that's to be determined in Paris.
Yeah, right. Judgment, para 74.
Oh, yes. So what Mr Justice Fancourt says is, I cannot accept the argument that any rights conferred on FV debt and ether by clause 5A was subject to proof by them and therefore always liable to challenge by the defendant, that what was done by way of enforcement action was or was not lawful. To construe the clause in that way would deprive it of much of its commercial effect, once it is accepted that it extends, as it does, to anything done by the company parties after enforcement action is taken to attempt to undermine its effect. Although that means that the company, and these are the important words in the paragraph, although that means that the company parties were giving up their rights of recourse to the court to adjudicate on the lawfulness of what FV debt or either might do, both the language and the circumstances are sufficiently clear in my judgment. That is what was being agreed as the price of giving the defendant the chance to refinance its subsidiaries' debts.
I suppose that reasoning is directed to 5A, not 5D.
It makes no difference, I don't think, in this context. Because 5D is effectively, don't put a block on enforcement. 5A is assist enforcement. In my submission, the learned judge here identified no adequate evidential basis for that reading of the commercial realities of the bargain reached between the parties. There is no reason to conclude that the bondholders agreed to a standstill as an enormous and uncommercial act of charity towards the appellant, such that it was a perfectly reasonable bargain for the appellant to give up its right of access to the courts. The obvious commercial truth is that it suited the bondholders for the period for redemption of the bonds to be extended, because they wanted the cash in preference to the securities they had. And so they...
What are they? What did the appellant give up?
The appellant gave up interest, and it gave up a series of contractual estoppels. But it didn't need to give up very much more. It was paying a high rate of interest, and ultimately it was in the interests of the bondholders, as they saw it commercially, to give the issuer an opportunity to redeem the bonds, because it looked to the bondholder, to the issuers, not to the bondholders, that refinance was likely, and they preferred cash. And then there came a point after a number of months and extensions where it became clear to the bondholders either that the cash position was not going to be regularised.
Yes, but just go back before the standstill agreement. The bondholders had various rights under the various documents, including the security documents, and enforcement action of a security is almost always a unilateral action by the secured creditor, which he undertakes without recourse to the debtor, which the debtor is usually opposed to, might well try and stop. So what is it that the appellant is agreeing not to do in the additional agreement, given that what we're talking about is unilateral action taken by the secured creditor to the disadvantage of the debtor?
But also, as the commercial realities that were apparent to the creditor at the time were, also they did that to the disadvantage of the creditor. The creditor did not, on the face of it, want to enforce its securities. The creditor wanted the cash that redemption...
Well, that may be the reason for the standstill. I don't have evidence about that, but let's assume that to be correct. What is the appellant giving up?
There's a coincidence of interest. It doesn't need to give up very much, but what it did give up was ongoing interest, as I understand it, a rate of about 27%, plus a number of contractual estoppels.
But then if you say there's an identity of interest and so on, there would have been no need for any agreements at all. They just wouldn't have been forced. They just sat on their hands.
They've got something. They've got a series of contractual.
What does clause on your submission? What does 5D give?
5D.
What are the company parties giving up? Because as I understand your agreement, you're saying that the company parties are not giving up the right to go to the court in Paris, for example, in relation to the trust agreement, or presumably the courts of Luxembourg in relation to the other security agreements. So what are they doing? What do these words mean? What's the content of them on your submission?
Broadly speaking, in very broad terms, 5D says we will not impede the lawful exercise of your enforcement, and 5A says we will provide assistance to the exercise of your enforcement.
But the means of contesting the exercise of rights by the agent realistically involves going to court, doesn't it?
Yes.
So the word contest almost certainly means go to court to try to stop.
It would do if what we're talking about is lawful. It would prevent it if it was what we're talking about was lawful behaviour.
But then they're not giving up anything, are they?
They're giving up very little. They're giving up a number of contractual estoppels. They did not have to in the commercial circuit.
Sorry, just to interrupt you. I'm so sorry. But in 5D, leave aside all the contractual estoppels and things. What are the company parties giving up? Because you're saying that they preserve the right to go to court to contest the exercise of the rights. So it doesn't seem to have any content.
It has a how can I put this without? It is fairly general provision. It is not something that requires or envisages the sort of close textual interpretation which, in my submission, your Lordship is currently engaged upon. It broadly requires the company parties not to interfere with the lawful exercise of actual rights.
Right, so just take as an example, the bondholders or the agents notify the appellant, we are going to take step X as part of the exercise of part of the enforcement action. And we are entitled to do that because of clause whatever it is in whatever agreement it is. And the appellant says, no, you're not. So the appellant goes off to court. Court rules that, in fact, the proposed step was lawful.
Was lawful.
Was lawful. They had that right, despite your contentions that they didn't. Are you in breach of clause 5D?
Then in those circumstances we would be, and it would sound in damages, one would assume. So my conclusion on my first point, and I guarantee that my second and third will be much, much shorter, is that paragraph 5D, properly interpreted, does not prevent the appellant from seeking the protection of the courts against illegality, and then it falls that the obligation in paragraph 5A to assist enforcement action cannot sensibly be interpreted as requiring the appellant to assist unlawful enforcement action. Can I move to my second point?
Yes.
This arises out of paragraph 75 of the judgment, which is at page 186. Sorry, 86. Typing in my handwriting. Further, the claimant accepts that the restriction on challenging enforcement action could not, as a matter of interpretation, prevent challenge to conduct which is fraudulent or dishonest. That concession is obviously appropriately made. Nor the claimant accepts could it extend to seeking to prevent something that is manifestly not enforcement action as defined at all. Although I don't propose to take the court to it, that is the position which my learned friend maintains at paragraph 41, first skeleton. Now, there's been no reliance upon any authority to justify this exception to the supposed contractual prohibition against commencing proceedings. And so one is forced to draw the inference that my learned friend made this submission to Mr Justice Fancourt and repeats it to your lordships as a way of mitigating what she recognises would be the somewhat unpalatable consequences of her basic submission. So going back to 5D, at page 139.
If you're looking at an exemption clause in a contract, they would such a clause would never be interpreted as excluding liability for fraud of a party to the contract. Not least because it's against public policy to exclude liability if you're Do you need authority for that?
In an exemption clause, possibly not. But this is not an exemption clause. This is a entirely freestanding provision in a bespoke contract. So what my learned friend proposed and Mr Justice Fancourt agreed was in essence the insertion after the word that on the first line of paragraph D of the words, quotes, save in cases of fraud, dishonesty, and when there is no genuine enforcement action. But there's no principal basis identified for this, nor was any explanation given for why only these and not illegality should form the exceptions. Obviously, fraud is a standard ground for setting aside a compromise agreement which has been reached by fraud. There's a provision that, or the position that you actually referred to in relation to exemption clauses. There's fraud as stroke iniquities and exception to legal professional privilege, but not here. Those are different. Those are different and discrete situations. And so if any words were to be inserted, and if I'm correct in my ordinary interpretation of this paragraph, I recognise that there is no necessity for the insertion of additional words. But if there has to be, and my learned friend says that they do, they should not, in my submission, be limited in the way accepted by Mr Justice Fancourt. There should also be an exemption for illegality. I turn to my third and final point as I approach speaking for twice as long as I indicated I would. It's a cheap one, I'm afraid. But cheap points can sometimes be illuminating. Paragraph 56 of her skeleton argument, my learned friend refers to the Paris Proceedings, and I don't need to ask you to turn it up because I'll quote it. The opportunity to delay enforcement through formalistic complaints. That's how she.
What are we looking at?
Paragraph
56, I thought you said. Scope of this release must be read with the rest of the additional agreement.
It's the last.
It's the very last paragraph. Very last sentence.
I see. Formalistic complaints, yes.
And to delay enforcement.
Yeah.
Now, the point is this, my lords, if the proceedings in the Paris court had no merit, it would have been perfectly possible for the respondent to address them directly. And one assumes obtain a relatively swift summary judgment.
In Paris?
In Paris. It didn't do that. Instead, and at vast expense, it decided to institute entirely independent proceedings in this jurisdiction.
Can you get summary judgment in the French court?
I don't know. I'm assuming
You're
that,
saying that's
no,
what they should have done.
I'm assuming that the same as we do. I'm assuming that the law, in the absence of any alternative submission, is the same here as it would be there, and one would anticipate that you can. But they simply haven't engaged in those proceedings. They've decided instead to issue proceedings here. There is no identified benefit to delay. There's no filibuster going on so far as the appellant is concerned. It doesn't gain any advantage from any sort of delay. And so one is entitled to draw an inference, I suggest, about what the respondent considers its prospects in Paris might be if it were to engage with them. And one is entitled also to draw an inference as to whether the proceedings that have been started there are formalistic or indeed have merit. And so, winding up, my three submissions are: number one, especially bearing in mind what would be waived if Mr Justice Fancourt's reading of 5D is correct, and looking at the clear wording of the provisions of 5D, it does not prohibit the proceedings in Paris. The second is, if we're going to imply any words into 5D, they should include the word illegality. And I've just made my final submission, and I won't repeat it because it's cheap, unless I can be of further assistance.
Thank you very much. Yes, Ms. Bowes.
My Lord, I propose to address you on the following topics. First of all, legal principles, which I can deal with very shortly. Secondly, commercial context. Thirdly, contractual context. Then dealing with the construction of Clause 5A. And finally, turning to construction of Clause 5D. As regards legal principles, there was, we thought, an area of dispute between us. It seemed to be suggested that there was what we described as a novel principle, that a term of a contract abrogating a party's right of access to the courts must admit of no other meaning. In fact, I think my learned friend has indicated that they are relying upon the clear words principle, which is referred to by the judge in paragraph 54 of the judgment. And so I need say little more on that. It is a uncontroversial principle, and it was very much recognised.
I'm not sure about that. I thought Mr. Brodie took us to is it paragraph 9 of Mr. Craig's skeleton, page 23, and in which it said that the term must admit of no other meaning, and I think he maintained that submission.
I may have misunderstood. When you pressed him by reference to unison, which refers to clear words in the context of legislation, I had understood him to step back from that principle. In any event, if it's relied upon, we say it's wrong. The principle is the uncontroversial one, which was relied upon by the court, that you need clear words where a party is giving up a right, and the more valuable the right, the clearer the words need to be, and that was the test applied, and it's the approach that I propose to follow in my submissions.
For the avoidance of doubt, I agree with that.
You agree that?
I
You
agree
agree as a principle?
my position is that there's no real difference between what Mr. Craig said and the use of the word clear words in unison judgment.
Turning to commercial context, I'd like to explain three aspects of the commercial context in which both the standstill and the additional agreements were made. The first heading is the hierarchy of security for the bonds. The second is the rights of the bondholder on the date of the additional agreement. And the third heading is the position of the issuers and the appellant on that same date. So dealing first with the hierarchy of security, if I could ask you to turn please to the supplemental bundle at the very back, tab 25.
That's the bigger of
It's
the
in
two.
if you've got it in 2 volumes, it's volume
Yeah,
2.
it's the bigger one.
It is, yes.
25.
Tab 25, right at the very top. And it's a one-page, it's a structure chart, and we're looking at the very last page, which is page 766. This may be a helpful diagram to start with. It shows the corporate structure chart now. And I'm focusing on the part at the bottom of the page. There's a dark blue box which gives the name of the company. That's the company which owns and operates the hotel in the south of France. And above it, we have a grey box, Poseidon, that's the parent. And then above it is an orange box, which is labelled Seaside Serenity. So until the 25th of May of this year, the parent was owned as to 50% by the appellant and 50% by another company called Financière Luminaire, which is referred to in paragraph 7 of the judgment. So until that date, the orange box, which is currently Seaside, would have been 2 boxes. Since the enforcement of the Lux share pledge, which I'm going to refer to in due course, the new owner is Seaside Serenity. Just for completeness, so that you see the full picture, onto the right of the diagram, you see a grey box with Catbalogan Holdings, that's my client, and above a pale blue box, which is Azure. And this shows that the whole structure is now owned by my client and its affiliates since the enforcement of the Lux share pledge, which has not been challenged. If you could turn, please, to the judgment of paragraph 9, that's in the core bundle at tab 6, looking at page 73. This is a useful reference point for the forms of security that we're concerned with. And
Judgment, paragraph 9.
Paragraph 9, please, my lord. Page 73.
Yes.
So the judge here sets out the security for the debt of the company and the parent under the bonds. And there are 3 things. We see in judgment paragraph 9A a reference to the Lux share pledge. And by that, the appellant and Financière Luminaire pledged their shares in the parent as security. And then in 9B, we have a reference to the Lux receivables pledge. Again, the same 2 parties, the appellant and a Financière Luminaire, pledged the receivables owed to them by the parent. So those 2 securities in A and B operate at the parent level in the corporate structure I showed you in the diagram. Then in clause 9C, or paragraph 9C of the judgment, I should say, there's a reference to the fiducie agreement. And by this instrument, the parent transfers its shares in the company to the trustee, that's ALO, and that is trustee of a trust created as security for the obligations of both company and parent. And so that security in 9C operates at the company level in the corporate structure. The parent is putting its shares in the company on trust as security. The appellant and Financière Luminaire are not party to the fiducie in their capacities as 50-50 owners of the parent. If we could look, please, in the supplemental bundle at tab 8. This is the fiducie.
Just hold on a minute. So just say that last bit again. So the appellant and
The appellant
FL.
and Financière Luminaire, so until enforcement in May of this year, they were 50-50 owners of the parent. Yeah. In that capacity, they were not parties to the fiducie agreement.
Yeah. Okay, now you want us to look at
the fiducie, so it's supplemental bundle tab 8, page 117. And I'm showing you the front page of that document because it indicates who the parties are. Financière Luminaire is not a party to the fiducie at all, it's not listed. The appellant, UNIK, is listed, and we see it the penultimate one listed, but it is only a party to the fiducie as initial second-ranking creditor beneficiary. Just to briefly understand what its role is within this document, we could turn to page 121, where we're looking at the preamble. and preamble B describes the monies owed to the appellant by the parent. The parent is the pledgor under this document. And we have in B a description of 3 loans which had in the past been made by the appellant to the parent company. And those are collectively described at the bottom of B as the UNIK intra-group loans. Then turning over the page, my lords, to page 122, we can see in recital F, it says, as security for the pledgeor's obligations under various things, including the UNIK intra-group loans, this trust agreement has been entered into, and it goes on. And at the end of F, it says, it is specified that the repayment of the UNIK secured liabilities is conditional upon the repayment of the Rajara secured liabilities. Now, the original bondholder was Rajara, and this shows us that the original bondholder must be paid first and that the appellant is the second ranking creditor. One sees that from elsewhere, but this is a convenient place to show you that.
This is a subordination provision.
It is, my lord, yes. So that is the status of the security that's referred to by the judge. Now, the significance of the hierarchy I've just explained is that if the bondholder enforces the Lux pledges, it takes control of the parent, the company, and the hotel. It is the ultimate enforcement step. It renders unnecessary, in effect, the enforcement of the other security, including the fiducie. I'll just break that down for a moment by explaining briefly the consequences of enforcing each document. Taking first, what are the consequences of enforcing the Lux share pledge? Once the bondholder has enforced the Lux share pledge, the bondholder or the person to whom the bondholder they sell becomes the owner of the parent. And as the owner of the parent, it controls the company. It's the sole shareholder, and it can exercise rights as a shareholder to do whatever it likes at company level. And that includes replacing the management, by way of example. That remains the case even though the fiducie is still in place, if the fiducie has not been enforced. If it's helpful, I can show you how the parent exercises control of the company via the fiducie, but that may be a level of detail more than you need, I'm not sure. I'll take it
But the enforcement of the Lux pledge in the way you've described doesn't itself bring the fiducie to an end?
It does not, that's true. Let me show you within the fiducie what happens in that case. Let's proceed on the assumption that there has been enforcement of the Lux share pledge, but there hasn't been enforcement of the fiducie. So that's the factual premise that let's work on. If we could look, please, back at the front page of the fiducie. So we're in the Supplemental Bundle tab 8, page 117, and we can see that the trustee alone is the pledgor. It is formally the shareholder in the company, but it has to act on, the trustee must act on the instructions of the pledgor, which, as you can see, is the parent. We see that from this page. And the particular clause I want to take you to is clause 9 of the fiducie on page 143. You can see it's headed General Mission of the Trustee. And clause 9.3 within that says, without prejudice to any obligation or prerogative provided by law, the trustee shall have the principal responsibilities listed below and shall be vested with the widest powers and jurisdiction necessary for the performance of the related duties. And then turning over to page 144, we have clause 9.3C1, which is at the bottom of page 1.
Sorry, just a minute. 9 point.
So we're still within 9.3, but
There we are.
little c, can you see little c is headed at the bottom 144?
Terms and conditions.
Terms and conditions for the exercise of voting rights in respect to the securities placed in trust. And we're particularly focusing on little 1, which starts before a triggering event occurs. So a triggering event is the commencement of an enforcement action under the fiducie. And then below that, it says, until the date of occurrence of a triggering event, exercise the voting rights in respect to the securities placed in trust for any decision listed in Annex 12, routine decisions, so long as no event of default has occurred or is ongoing in accordance with the written instructions of the pledgor only. Now, we don't unfortunately have Annex 12 of the fiducie in the bundle, but it's a whole list of activities, including dismissing and replacing officers of the company, as you might expect from the general description routine decisions. So by that means, if the bondholder has become the owner of the parent, the trustee, alone, has to take instructions from the parent unless and until there has been a triggering event. So in this world in which there's been an enforcement of the pledge but not the fiducie, that's the situation. I talked about the consequences of enforcing the Lux share pledge. There are two Lux pledges, and the second is the Lux receivables pledge. I'll just focus for a moment on the consequences of enforcing that. If the bondholder exercises the Lux receivables pledge, then any money which would have been due to be paid by the parent to the appellant, for example, in repayment of the loans, is no longer due to the appellant. The bondholder has taken those rights. So upon enforcement of the Lux receivables pledge, the appellant no longer has any interest secured.
Any money payable by the
parent
to
the appellant. So I showed you earlier about those UNIK intergroup loans. Those were loans by UNIK, the appellant, to the parent, of which it was the 50% owner, and those are pledged in the Lux receivables pledge. If it's enforced, they no longer have the rights. I could take you through the Lux pledge, receivables pledge in a bit more detail if that would be helpful to see how that happens. Maybe let's do that. It won't take very long, I hope. So we're in Supplemental Bundle tab 11. And starting on the front page, we can see who the parties are. There are two...
Sorry, and sorry, I'm just trying to, I'm a bit behind you, but the rights of the defendant, the appellant, the defendant, as a secured creditor under this fiducie agreement are those liabilities that you just talked about. Is that right? They're the
Yes.
amounts owing by the parent to it.
Yes, exactly.
So if those are switched over to the bondholder, then the defendant no longer essentially has a secured right, any rights which are secured under the French agreement.
Yes,
Is that the
exactly, my
punchline?
lord. Yes,
Yeah, I see.
that's my punchline. Thank you.
Uh,
It may be helpful to show you in the receivables pledge how we get there, but the means by which
Yeah.
those receivables are pledged in order to make good my point. The receivables pledge, we're on the front page of it, and we can see that the first of two pledgors is UNIK Bond S.A, that's the appellant. And then the agent, Ether, is the pledgee. And then Poseidon, that's the parent, and it is the debtor under this agreement. And then if we could turn to page 292, we have recital A, that just refers to the bonds, and then more importantly, recital B. The pledgors, so that's the appellant and another, are or may become from time to time, as the case may be, owners of the receivables as defined below. And then recital C over the page, the pledgors have agreed to grant a pledge over the receivables as defined below to the pledgee, the agent, as security for the secured liabilities in accordance with the terms of this pledge agreement and subject to the terms of the intercreditor agreement. And there are three definitions which we will need in a moment, and they are found on the same page 293. The first is the definition of intercompany loans agreements, which are the loans that are described in the fiducie that I showed you in the recital to the fiducie. Then there's a definition of receivables, and that covers any receivable owed by the parent to the pledgors. So that includes the sums owed under those loans. And then over the page, we have a definition of secured liabilities. And those are defined by reference to various other defined terms. And if you follow that through, it includes the sums owed by the parent and the company under the bonds to the bondholder and the agent. So the operative provisions are, they start on 295, clause 2. We can see as continuing first ranking security interest for the full payment, performance and discharge of the secured liabilities, the pledgors agree to pledge and hereby pledge the receivables. So that includes their right to payment under the loans. And then on page 301, we have clause 8, headed enforcement of the pledge. I'll come in a little bit more detail in a moment to this provision and its equivalent in the other pledge. But once there is an event of default, which is also a Luxembourg security enforcement event, the pledgee is entitled to enforce under a variety of methods, including the sale or appropriation of the receivables. So if the receivables, including these loans owed to UNIK, are sold or appropriated, then the appellant is no longer a creditor of the parent company under the intragroup loans, and it's the new creditor is whichever entity has bought the receivables or appropriated them. So the observation to draw here, my lord, is that the Lux pledges are really a sort of nuclear option in the menu of enforcement. It leaves the appellant without its 50% shares in the parent and without the right to be repaid its loans made to the parent. I'm just going to divert for a moment because you may be wondering, in practice, why did we bother to enforce the fiducie at all in May of this year if we could simply enforce the pledges, take the parent and control the company that way? This is a side shoot, but I want to address the question because it seems to me to be one that it may have occurred to you already. When we enforced the Lux pledge in May and sold the shares in the parent to Seaside, that's the orange box in the structure chart, the new owner obviously wanted to ensure that its own people were in charge of managing the hotel. They wanted that chart change to be made immediately. Ordinarily, they could have done that by exercising rights as shareholder, subject to the fiducie, exactly as I've described to you, to remove Mr Cardy and appoint new management. In fact, in this particular case, there was a hitch. The parent was at that time in receivership proceedings in Luxembourg. Those proceedings were a result of a breakdown in relationships between the previous shareholders of the parent, that's to say the appellant, and Financière Luminaire. And among other things, they had been unable to agree the statutory accounts of the parent.
Well, you're telling us all this. Is this in evidence somewhere?
There was some evidence in relation to it before the judge. It hasn't come out in judgment because it doesn't really matter. If you were not troubled by it, then I don't need to trouble you with it. But I just wanted.
I don't mind the explanation as long as it's in materials that were before the judge.
In part, not the entire story. It came up in my reply submissions to answer an issue that had come up, and it occurred to me that you may have the same query, and I'm trying to be helpful and address that. But I recognise that I don't have a witness statement to point to, which tells the whole story. It may be sufficient to say that there was an unexpected event in May, which meant that we couldn't do that which would have been the natural order of things, which what we're concerned with now, of course, is construing the additional agreement and the standstill agreement on the 11th of November last year, when this particular issue would not have been foreseen.
But it may be of some relevance, tell me if this is right or wrong, that if UNIK wished to challenge the enforcement of the pledges, either of them, it would be doing that in Luxembourg, not in Paris.
That is true, but it has not done so,
No.
and it acknowledges in these proceedings that it has given, well, until today, which a slightly different submission was made, it had conceded that it had given up the right to challenge the Lux pledges. And I'll take you in a moment to where one sees that within the argument. So that hasn't happened, and it's not expected to happen given the concessions made within the course of these proceedings.
Your submission is that once the Lux pledges have been exercised, there's really very little left, is that?
Exactly, my lord. It's game over, really. And that was very much, and my point really is for the purposes of this debate, that was very much on the horizon on the 11th of November last year. That was very much the scenario that was envisaged, and I'll come on to explaining why that's so. So I've explained the hierarchy of the structure in place. It's important also to see that the significance of enforcing the Lux pledges is reflected within the contractual structure. If we could turn, please, to tab 13. So we're in the supplemental bundle. Tab 13 is the parent bonds, terms and conditions. So we have, as you know, two sets of bonds. There's the parent bonds and the company bonds. They each have parallel sets of subscription agreements and parallel terms and conditions, but they're in materially the same terms. So I'm just going to take the parent bonds ones, which are at tab 13. If we could turn, please, to page 648. And at 648, you should see clause 20, events of default. And within that, I'll just highlight a couple of particular clauses of relevance to what follows. Clause 20.1 is headed non-payment, and that is where the issuer does not make a payment due under a finance document. That could include failure to pay bonds at maturity, but there are other possibilities too. Then I also draw attention to 20.5, cross-default and cross-acceleration. And over the page, 20.6, insolvency, and it's worth looking at the language of this a little bit more closely. The issuer, the target, is unable or admits inability to pay its debts as they fall due, or is deemed or declared to be unable to pay its debts under the applicable law, or suspends making payments on any of its debts. And then 20.7, insolvency proceedings. So this event of default provision is an important one, and it has a number of different possible consequences depending on which security you look at. So the next logical question is, what rights arise upon these various different events of default? And for this purpose, if we could look back, please, and tab 8 for the fiducie. And focusing on page 155, please. So clause 12.1 would be starting at the bottom of page 1.
Sorry, just a minute, I'm behind you. Clause 12.1, yes.
And it's headed occurrence of triggering events, and 12.1 is definition of the triggering event. 12.1a says each of the following events will constitute a triggering event. And then there's a list over the page, little 1 through little 8. And the first one is a notification of the occurrence of an event of default in accordance with the provisions of Article 20 of the parent bonds terms and conditions. And the reference is to the other company bonds. The numbering is slightly different, but they substantively say the same thing. So the point to observe here is that any of those events of default, which I showed you in clause 20, not just the ones I highlighted, but any of them, amount to a triggering event for the purposes of the fiducie. We also note here clause 12.1b, which is just below. It says the occurrence of a triggering event and any action under this trust agreement shall be deemed to have occurred and shall be effective on the date of the notification of the triggering event sent by the agent to the trustee. A model of said notification is attached in Annex 11. So the triggering event depends upon the sending of a notification, a capital N notification. So that's how the events of default interact with the fiducie. Turning then to the Lux
Ask
share.
a question. What about little 2? Is that the bonds presumably are secured liabilities, aren't they?
Yes.
So that's a separate route, is it right?
Indeed, my lord. So there's an overlap really between 20.1 non-payment event of default and what's being described in little 2. They could be interchangeable.
2 doesn't require a notification, does it?
Yes, because
It's a triggering event.
it's a trigger.
So it requires the notification under B, is that right?
Yeah, everything in little a.
But it is a triggering event automatically, is that right?
No, because if you go back to the previous page 155, 12.1a says each of the following events will constitute a triggering event. And then the occurrence in NMB says the occurrence of a triggering event is deemed to have occurred and shall be effective upon a notification. So until there's been a notification, there won't be a triggering event. You need one of those things in little 1 to little 8 to happen and then do a notice in order for there to be deemed to be a triggering event. That's my reading of it.
It doesn't need, sorry.
Yeah.
Little 1, the reference to notification there means presumably notification under the bonds. 2 is just non-payment of the bonds. And then there's a separate question of notification under this agreement.
So you're
really
suggesting there's 2 layers of notification required. A little 1 notification followed by a capital N notification in B. That is not something I've focused on and hasn't arisen, but you may be right.
Probably doesn't matter.
I've looked at how the events of default interact with the fiducie. Turning now to the Lux share pledge. We're in tab 10 of the supplemental bundle. And focusing on page 279. Which is headed rights attaching to the shares, and 6.1 in particular, right to vote. And I'm homing in on sub C. Upon the occurrence of an event of default, which is continuing, the pledgee shall be entitled to elect, by notice sent in writing to the company and the pledgors, to exercise the voting rights in relation to the shares in any manner it deems fit for the purposes of protecting and or enforcing its rights under the pledge agreement. So any of the events of default in clause 20, which I showed you, give rise to a right to exercise voting rights in the shares of the parent. And also note, if the right to vote arises if the pledgee elects to exercise it, it does so by sending a notice in writing. Then we turn, please, over to, in fact, it's on the next page, page 280. So we're still within the Lux share pledge, but we're looking at a different form of enforcement or different exercise of right. This is in clause 8, enforcement of the pledge. And clause 8a says, at any time following the occurrence of an event of default which is continuing, but subject to the provisions of paragraph B of clause 10.1 of the intercreditor agreement, the pledgee is entitled to enforce the pledge immediately at its absolute discretion. So if the conditions are met, the entitlement is immediate, not upon the giving of notice. But to see if the conditions are met, you have to look in the intercreditor agreement. So we'll go there. That's in tab 9.
And that required agreement with the company parties, I think, didn't it?
Sorry, say again?
It required agreement by the company parties to enforcement under clause 8, but not clause 6. Right?
No.
No?
Clause 8a allows, as long as there's an event of default, which is continuing, but subject to the provision I'm about to take you to, then the bondholder can immediately enforce the pledge.
Yes.
And take the shares in the parent. So there's no agreement stage required there.
I thought that was under the intercreditor agreement. No? Perhaps not.
Well, I'll show you the intercreditor agreement referred to here, and that may assist. So that's in tab 9 of the bundle, and focusing on page 224. So here I'm showing you clause 10.1 of the intercreditor agreement, which was the clause specifically referenced in clause 8 of the pledge. And it's headed enforcement of security, and 10.1 enforcement instructions for transaction security. And then 10.1a, subject to the transaction security having become enforceable in accordance with its terms, the instructing group may give or refrain from giving instructions to the security agent to enforce or refrain from enforcing the transaction security as the instructing group sees fit. And then it carries on in B over the page. Notwithstanding paragraph A above, the instructing group shall refrain from instructing the security agent to enforce a Luxembourg transaction security unless any Luxembourg security enforcement event has occurred and is continuing. Just to focus on some of the defined terms used in that important provision 10.1b, Luxembourg transaction security meant the Lux share pledge and the Lux receivables pledge. As regards Luxembourg security enforcement event, let's look please at page 193 within the same document for the definition. So on page 193, we have a defined term, Luxembourg security enforcement event, and it means any of the following enforcement events. And there are 4 listed. The first is the parent or the company is subject to any of the events and circumstances referred to in clause 20.6, insolvency, or 20.7, insolvency proceedings, of the parent bond's terms and conditions. And the equivalent for the company bond terms and conditions. And I also draw your attention while we're here.
Can I just ask a question about that? In the judgment at paragraph 39 on page 78 of the core bundle, looking at clause 4 of the additional agreement, the judge says that the additional agreement confers a further right in the event that full redemption does not take place, namely the agreed occurrence of a Luxembourg security event as defined in the intercreditor agreement being the insolvency of the company and the parent. Is it not all the parent?
Well, either will do.
Yes.
But
I mean, in fact,
clause...
the acknowledgement in clause 4C applies to both, but you only need one. As I
yes,
understand it.
My lord, that is accurate, yes. But I think he's referring to 4C,
yeah.
Which gives a contractual estoppel, which relates to both.
Yeah.
The parent and the company in the opening words of clause 4. Yes. So whilst we're still in the Luxembourg security enforcement event definition, I also draw your attention to B. Which is this is another alternative thing which can be a Luxembourg security enforcement event. Any litigations or other actions or inactions of any nature whatsoever, including for the avoidance of doubt, actions, inactions, challenges, motions, or any filing of whatsoever nature within the fiducie enforcement process or the forced sale process or the appropriation process are threatened, implied, or initiated by the company, the parent, or any of the investors, that includes the appellant and or their representatives, which in the reasonable opinion of the majority senior creditors, that's the bondholders, are aimed to achieve the nullity, resolution, cancellation of, or otherwise challenge the fiducie agreement or any of its effects, or aim to suspend, cancel, delay, postpone, or otherwise challenge any fiducie enforcement process provided under the fiducie agreement. So standing back from this definition, what this shows, at the moment the bonds were issued, any event of default was sufficient to enforce the fiducie. Any event of default was sufficient to exercise the voting rights under the Luxembourg Share Pledge. Enforcing the Luxembourg Share Pledge has a more demanding threshold. There has to be one of these Luxembourg security enforcement events. And among the events of default, which are captured, there are just two: insolvency or insolvency proceedings. Those two events of default are the only ones which count for a Luxembourg security enforcement event. Alternatively, if the bondholder had already taken steps to enforce the fiducie, perhaps pursuant to one of the ordinary events of default, and the appellant did anything to challenge those steps, there would immediately be a Luxembourg security enforcement event with potentially draconian consequences. So the point to make here is a quick one on the side, which is built into the original framework of this whole structure, is what could amount to quite a severe limitation on the appellant's ability to challenge the fiducie. In a world where the bondholder has only enforced the fiducie, but not the Lux pledges, the appellant can't even threaten or challenge the fiducie in any way, the fiducie enforcement process, without bringing on a Luxembourg security enforcement event. That's part of the framework that we have at the beginning here. The final point to note in this context is back in the Lux Share Pledge, please, tab 10, looking at clause 8 again, on page 280. We already looked at clause 8a, the very first part. If we could look now at the second part of clause 8a, you can see it on page 281. There's some indented text, which is part of the first paragraph, and then it says the pledgee shall in particular be entitled to. Do you see that, my lords? So on page 281, the pledgee shall in particular be entitled to, and then there are 5 sub-paragraphs which contain different options. And at little 2, the option is appropriate the shares at their fair value as determined by the expert. And then 8b, which is below on the same page, provides that in the event of an appropriation pursuant to clause 8a, little 2 above, the pledgee will, and then there is provision for the appointment of an expert. And I wanted to draw this to your attention because this is the clause which is replaced by clause 5c of the additional agreement, which I'll show you in a moment, but there's a new provision in 5c of the additional agreement relating to the way in which the expert is to be appointed. It makes just a few tweaks to that process, and it may be useful to put in context what it is it's replacing. But you can see that the right to appoint an expert arises both in the original here and in the amended form only when there has already been a Luxembourg security enforcement event, and then also only in the event that there has been a decision to appropriate under little 2. My lords, those are my submissions on the hierarchy of the security. I'm afraid it takes a little while, but it shortens submissions later and perhaps is more convenient to take it in one go. I turn to the second topic under this heading, which is the rights of the bondholder by the 11th of November 2024. The state of play by that date, when the standstill and the additional agreement are entered into, is this, and we can see it in the judgment at paragraph 11, so back in the core bundle, tab 6 of the core bundle at page 74, we can see at paragraph 11 the judge records that the bonds were due and payable on the 6th of September 2024. They'd not been repaid. There was an event of default. It was a clause 20.1 event of default, and the agent had reserved its rights and allowed time to refinance. Just on that topic, if we could look please at the supplemental bundle, which is in the and tab 14 in particular. Tab 14 is a letter dated the 12th of September 2024, and it's the letter by which rights were reserved. If you just turn over to the second page of the letter, page 671, and you can see in paragraphs 2 and 3 of the letter, those state that there has been a non-payment event of default and a cross-default and cross-acceleration event of default. So the rights have been reserved at this point, soon after the bonds have matured without payment, and the bondholder is drawing attention to two events of default, which I might call ordinary events of default. They're not Luxembourg security enforcement events. There's been no allegation at this stage that there's been an insolvency event or an insolvency proceedings event of default. And the judge at paragraph 32 records, based on recital B to the standstill agreement, that by this date there was no dispute that the company and the parent were in default and the debt had not been repaid. So what rights did the bondholder and the agent have on the date of these two agreements? Because there had been, if I can call them ordinary events of default, they had the right to enforce the fiducie, to be exercised by sending a capital N notification of a triggering event. So that was one right that they had. They also had the right to exercise voting rights in the parent. That was a right under the pledge, and it could be exercised by sending a written notice. And it was effective on any of the events of default, and some of them had happened. But no notices under either of those provisions had been sent by the 11th of November. What rights did the bondholder and the agent not have on the 11th of November 2024? Well, first, the right to enforce the Lux pledges. No Luxembourg security enforcement event had been asserted. Moreover, they did not have at that moment the right to appoint an expert to value the shares in the parent, again because they had asserted no Luxembourg security enforcement event and there had been no election to appropriate the shares. There were other rights that they did and did not have, but I draw attention to those because they're relevant to the arguments made by the appellant. So that is the position of the bondholder on the 11th of November. Turning finally and thirdly to the position of the appellant on the 11th of November. On that date, the appellant is still the 50% owner of the parent. The appellant and its structure faces imminent risk of the bondholder enforcing the security. As I've said, the ordinary events of default give the bondholder a platform to enforce the fiducie and exercise voting rights in the shares of the parent. And although it had not yet been asserted, the bondholder could soon contend that there had been a Luxembourg security enforcement event on the basis of inability to pay debts. So the appellant was on the brink of losing everything at the moment that this agreement is entered into. If we could turn, please, to the standstill agreement, which is in the core bundle at tab 12 on page 149. I'd just like to highlight recital C to the standstill agreement, page 149. The parent and the company have requested the bondholder to enter into this agreement to provide a limited period for the group to conclude a refinancing transaction to repay the bonds in full. And for that purpose, the appellant had negotiated a 3-week standstill for that purpose. There's no evidence as to why 3 weeks was the chosen length of time, but presumably it was considered by the appellant to be a realistic period in which to conclude the refinancing. Perhaps that's unsurprising. The bonds had already been in default for a couple of months, and one would in the ordinary course expect attempts to be made or steps to be taken towards refinancing before the bonds matured in order to try to get that in place. So what we have is an agreement as to a 3-week standstill for that purpose, concluding an attempt to refinance which had already been commenced. So that is the commercial context. I'm going to turn now to the contractual context. And against that backdrop, we look both at the standstill and the additional agreements, which are, as the judge found to be construed together. I'm going to deal with three preliminary points which feature in the construction arguments before looking specifically at clauses 5A and 5D. I'm not totally sure about the extent to which they're still relied upon, but it didn't seem to me that my learned friend was necessarily dropping any points, so I'm going to deal with this comprehensively. If there's any point that you don't need to be addressed upon, I will, of course, move on. So the 3 points that I'm going to address under this heading are the significance of clause 4. Secondly, the structure, language and heading of clause 5. And thirdly, a comparison between clauses 5 and 6 of the additional agreement. So, my lord, the first is the significance of clause 4. If we could look, please, at in the core bundle at tab 11 at the additional agreement. We're looking at page 138. And clause 4 is headed creditworthiness in the middle of the page. And the judge found at paragraph 39 of his judgment that this operates as a contractual estoppel as to current and future matters. By way of reminder, the company parties are three. They're the company, the parent, and the appellant. And clause 4A is an acknowledgement of the non-payment event of default. Clause 4B is an acknowledgement of an insolvency event of default. So one of the Luxembourg security enforcement events. That phrase, suspended making payments on certain of its debts, falls within 20.6 of the parent bonds terms and conditions, which I showed you earlier. And then for C is an acknowledgement that, but for the standstill, and unless the bonds are repaid and paid in full, the parent and the company are unable to pay their debts, which is also a Luxembourg security enforcement event.
So both B and C acknowledge that there is now a Luxembourg security enforcement event.
When you say is now, until the additional agreement is executed, the bondholder didn't have the benefit of these contractual estoppels. So before the contract, no. Once it's executed, the bondholder does have the benefit of these, but it can't use them until the standstill lifts because it's agreed to. So yes, I agree, but subject to that caveat about timing. And the judge clearly understood the significance of clause 4. He explains this in paragraphs 39 to 40, to which you referred
Well,
earlier.
he concentrates on 4C, but I think you're saying that 4B will do exactly the same job.
Indeed, my lord. Yes, he does focus on 4C, and that's probably my fault at trial for focusing him on it. It doesn't make very much difference because the two both have a similar effect, and neither of them will be operative until the moment at which the standstill lifts.
Well, I mean, it might have had significance because B is definitely an acknowledgement of things as they stand at the date of the additional agreement, whereas C is looking to the future. And there may have been a debate, I think you refer to a decision of Mr Justice Andrew Smith about whether these kinds of so-called estoppels can peer into the future. But there's no question that B doesn't do that.
That is right, my lord. It is actually in preparation for this appeal that I appreciated that B also, the language of B also speaks to clause 20.6. I don't think it changes anything, and I wanted for completeness to draw your attention to what 4B is doing for the parties, as it were, at this point. My point here is that the judge understood the consequence of this, and it forms an important part of the context in which he read clause 5, and you can certainly see that from paragraph 56 of his judgment. So that is the significance of clause 4. The second topic is the structure, language and heading of clause 5. And the appellant skeleton, paragraphs 14 and 15, make two submissions. It argues that the draftsperson drew a relevant distinction between the words undertaking, said to be an operative provision, and the phrase agree and acknowledge, which is said to be a mere contractual estoppel. And it also argues that Clause 5 is structured to contain in 5A an undertaking to cooperate, followed in B to D by a series of contractual estoppels as to matters accepted for the purposes of that duty of cooperation. And it argues that the heading to Clause 5 shows you that that structure is the right way to read the clause. As to the distinction of language, that's between undertaking and agreeing.
That didn't seem to me to be the way that Mr Brody was putting it now.
It may be that I don't need
He
to.
was saying Clause 5D is the key provision. What did UNIK agree to do or not do as a result of that provision? It didn't agree that it wouldn't challenge alleged illegality.
My lord, it does seem that his argument has moved on. Really, this is actually an argument about 5D, because although it appears to be about Clause 5 as a whole, what it's trying to say is the only operative provision is 5A, and 5D has some lower grade
I don't think that's the way
consequence.
it's now put. I think, well, it's my impression from the submissions we've heard this morning is that Mr Brody focuses on 5D as containing promises of one kind or another, and the question is, what do those promises mean?
Yes, my lord. And on that, he needs to win on A and D in order to change the outcome.
About that. Is it your, suppose you fail on 5D, is it your submission that 5A goes further?
They both have a parallel effect, but I would submit.
That's Mr Brody's argument. He says they're coextensive, in effect. He didn't use that word, but that was the effect of the submission, as I understood.
In my submission, 5D is much more obviously the operative provision here as relevance to these facts. But 5A, actually, even if we didn't have 5D, we'd have 5A, and that would be good enough because they have agreed to
Well, I
cooperate.
understand that. I mean, if they're coextensive, yes, of course, 5A would do your job.
Yes.
But as I say, my question is a slightly different one, which is assume you lose on 5D, can you get home on 5A?
Well, the language is different. There, in 5A, for example, we have the use of the expression enforcement action, which doesn't feature in 5D. So it's possible that depending on which of the arguments you prefer, you could reach a conclusion which was against me on 5D, but in my favour on 5A. They are framed somewhat differently, but they are driving in the same direction.
The other difference that might be noted is that 5D seems to be concerned with in this regard, with the exercise by the agents of its rights, whereas 5D, 5A concerns cooperation with the bondholder and the agent. So there's that difference of scope.
My lord, that is true, although the agent acts on the instructions of the bondholder, so there may be a limited extent to which that creates a difference in reality.
Yeah.
I will therefore skip what I was going to say further about the structure and heading of Clause 5 and deal with the third topic, if it's helpful, which is the comparison sought to be drawn between Clauses 5 and 6 of the additional agreement. This wasn't mentioned this morning, and I assume it's still relied upon. The appellant skeleton argument at 11B and 12 and 13 make an argument that the waiver or giving up of claims in relation to the purported exercise of rights under any of the security documents is the purpose of Clause 6, and therefore it is said that that can't be the purpose of Clause 5. We get that in particular from the last sentence of paragraph 12 of the skeleton. There's an acknowledgement that if Clause 6 principally conferred rights that could be exercised during the standstill, it would undermine that argument. And so the appellant says that the judge was wrong to reach that conclusion in paragraph 13 of his judgment. We address this in our skeleton at paragraphs 24 to 26. If I could take you, please, to clause 6 of the additional agreement. We're in tab 11, page 139.
Yeah.
And so in this clause, the company parties agree and acknowledge including without limitation for the purposes of clause 3.1 of the standstill agreement. You may recall, and I can take you back to if it's helpful, that clause 3.1 of the standstill provided that unless otherwise agreed in writing, the bondholder wouldn't exercise any rights under finance documents during the standstill. So here in clause 6, the parties are agreeing in writing to carve out something from that undertaking. Clauses 6A to C are all about the exercise of voting rights under the Lux share pledge, which the bondholder was entitled to do on the 11th of November because there had been an event of default. In particular, clause 6A confirms that the agent is entitled to exercise voting rights in relation to the shares under the Lux share pledge. And then B confirms that the agent may wish to exercise those voting rights during the standstill or otherwise, and that language is expressly used. And then clause 6C provides that the appellant won't contest the agent's exercise of voting rights and irrevocably releases claims, rights or claims in this regard. Clause 6D refers to the position of financier luminaire, that co-owner of the parent, which was not a party to the standstill or the additional agreement. And this provides or reinforces that the agent can still enforce its security in relation to financier luminaire's shares in the parent at any time, whether or not the standstill's expired. And then finally, clause 6E refers to a number of defined terms which it may be helpful to draw to your attention. It refers to the pledgors, that includes the appellant. It refers to the obligors, that's a reference to the parent and to the company. It also refers to the Lux share pledge and the Lux receivables pledge. Those are also referred to at the end of 6E as the relevant security. And it's acknowledging and referring to possible claims which the appellant may have against the parent or the company, further to an enforcement of the relevant security by any means whatsoever. And what that means is if the Lux pledges are enforced, the appellant may have claims against the parent and the company. And this clause is providing that the appellant irrevocably waives any such claims. There are 3 points to make about this clause, having just talked through what its effect is. The first is that the scope of clause 6 is different to and much narrower in effect than clause 5. The specific security that we're focusing on is different. Clause 6 is just about the Luxembourg pledges, those two. It's just two of the security documents, whereas clause 5 refers to all 7 security documents. It's also different in terms of the rights engaged. Clause 6 is mainly about the exercise of voting rights, whereas clause 5 is about all enforcement rights. And so it's wrong to say, as the appellant does in paragraph 12, that clause 6 does the job of giving up claims, and therefore clause 5 is not doing that job. Clause 5 and 6, they're doing different jobs, and they do work together, and clause 6 doesn't tell you anything about clause 5. The second point to make about clause... Sorry, were you about to ask me a question?
Yeah.
The second point is, as a matter of timing, the judge was right to say that clause 6 principally conferred rights that can be exercised during the standstill period. Now, only clause 6E is confined to the post-standstill period because it refers to claims that might arise further to enforcement of the Lux pledges. And we know that that can't happen until the standstill expires. So 6E is definitely post-standstill. But clauses 6A to D all apply during and after the standstill. Only clauses 6B and D actually state in terms that they apply during the standstill. We have that express language in those provisions. But A and C do too, because of the introductory wording to which I referred, that carve out from clause 3.1 of the standstill agreement. And I would also say that clauses 6A to D have little significance after the standstill has expired without repayment of the bonds, because the Lux pledges would be enforced in reliance on the contractual estoppels that we have in clause 4. Once the bondholder owns and controls the parent, it doesn't need to use the voting right provisions in the Lux share pledge to protect its position. So the judge was right to say, as he did in the judgment at paragraph 86, that clause 6 is principally concerned with rights that can be exercised during the standstill, because that's its real meaning in effect. And the third and final point to make about clause 6 is that the wording at the end of clause 6E, which is further to an enforcement of the relevant security by any means whatsoever, it's part of defining the scope of that provision. And a point taken against me is that the omission of that particular language in 5D tells you something. But in fact, the omission of equivalent language doesn't have any significance because these two clauses are doing different things. And the language appears here because it's defining the scope of what's going on in 6E. So those are the 3 points I wanted to make about the contractual context before focusing on the clauses in question. And turning to clauses 5A and D. Clause 5 uses a number of defined terms. Our skeleton at paragraphs 32 and 33 gives the references for those defined terms, and the judge was taken quite carefully to all of the definitions, and he recorded the meaning of at least the key terms in his judgment, I think, without any complaint. I wasn't proposing to take you to all the definitions, but I could do that if that would be helpful. It may assist, or it may be laborious and unnecessary, and I'd appreciate your indication.
Well, we've looked at quite a lot of these defined terms, haven't we, already?
We may well have done, yes, indeed. Some of them are a bit more in detail. The one I'm going to take you to in due course anyway is the definition of enforcement action.
Yeah.
But we can come to that within the context of a particular argument.
Yes, I think we will need to look at that.
Yes. So our skeleton, paragraphs 37 and 38, explains our positive case on the meaning of clause 5A, and I'm not proposing to repeat that. I would say, though, make the obvious point that clauses 5A and D need to be given some meaning. They may need clear words to do what I say they mean, but they have to have a meaning. And it seemed to me from my learned friend's submissions that he was suggesting it might be open to the court to reach the view that they don't mean what I say, but they don't have a clear other meaning. So I'm going to be responsive in my submissions on clauses 5A and D, and I'm dealing with 5A first of all. There seem to me to be 5 arguments to be dealt with, and I'll identify them and then deal with them in turn. And insofar as you indicate that it wouldn't be helpful to deal with any particular one, then I'll skip it and move on. So the first argument made by my learned friend, or in the skeleton argument, is, did the judge apply the right test? The second is the meaning of cooperate fully. The third is the meaning of enforcement action, capital E, capital A. The fourth is the meaning of may wish to take, which is a timing point. And the last and probably longest point is the commercial effect of the judge's construction. What was the appellant giving up? So the first point is, did the judge apply the right test? It is said in the appellant's skeleton argument at paragraph 17 that the judge made an error of law and failed to ask himself the right question. The right question is whether sufficiently clear words had been used by the parties to justify the conclusion that the appellant was giving up the right to challenge enforcement. And the judge recognised that this was the test. He set it out in paragraphs 53 and 54, to which you've been taken. He understood, and we see this in paragraph 55, the appellant's argument was that there was insufficiently clear language to enable the court to conclude that it agreed to give up its rights to take a future dispute about the lawfulness of enforcement action to the tribunal. And he repeatedly emphasised the test, and we see that in paragraph 65, and he overtly applied that test, rejecting the appellant's case on clause 5A. And we see that, for example, in paragraph 74 of the judgment, where he says, although that means that company parties were giving up their rights of recourse to the court to adjudicate on the lawfulness of what FV debt, that's the bondholder, or ether, the agent, might do, both the language and circumstances are sufficiently clear in my judgment. That is what was being agreed as the price of giving the defendant the chance to refinance its subsidiary's debts.
Yeah, he
And
poses,
likewise in
he poses the question at paragraph 65,
Yes,
and his answer is in 74 and 76.
exactly, my lord. So it cannot be said that he was addressing the wrong question in my submission. The second topic is the meaning of cooperate fully. This wasn't pressed by my learned friend, but nor did he drop it, so I will deal with it. This is in...
I will drop it now.
Thank you. Turning then to the third topic, meaning of enforcement action.
Sorry, just a minute. The dropping of cooperate.
Sorry, there's an argument
means,
about...
let me just
Yeah.
clarify, means that Mr. Brodie accepts that it is a breach of an obligation to cooperate in achieving result X, to take steps to prevent result X from happening. Is that right?
I'm sorry.
Mr. Craig's point was an obligation to cooperate requires you to do something,
Yes.
and if there's nothing that you need to do, then the obligation doesn't bite. But it might be said that if you agree to cooperate with my walking to that door, you are in breach of that obligation if you stop me from walking to that door, even though you didn't have to do anything. I could have walked there perfectly well myself.
I agree.
Turning to the meaning of enforcement action, this is in the appellant skeleton, paragraphs 19 to 21, where it's argued that the judge was wrong to find that the appellant was obliged to cooperate with enforcement action, which might be unlawful. And in paragraph 19 of the skeleton, it appears to argue that the phrase enforcement action, although a defined term, should be read to include or refer in some way to other provisions of the intercreditor agreement to which reference is made in the appellant's skeleton, paragraphs 19A to C. It wasn't completely clear to us that that's the way in which the point is being put, but in case it is, I was going to address it. If we could look, please, at the definition of enforcement action. So we're in the intercreditor agreement, which is in the supplemental bundle at tab 9. On page 189. Page 189 of the supplemental bundle, we're in the intercreditor agreement. We're looking at the definition of enforcement action. It's quite a long definition and we only need a few parts of it. The first part to focus on is A, which starts in relation to any liabilities, and then little 2, the making of any declaration that any liabilities are payable on demand, and also little 3 over the page, the making of any demand in relation to a liability that is payable on demand. And the other one we said was engaged was B, the taking of any steps to enforce or require the enforcement of any transaction security. And you will note that there are a number of other options, and then at E, there's a statement of what shall not constitute enforcement action. So the parties have gone to quite a lot of trouble to define this particular term and say what it does mean and include and what it does not mean and include. If I could just ask you to look briefly at paragraph 19 of the appellant skeleton to get your bearings. It's on, it's in the core bundle, tab 2, page 27. Starts on 27 and the subparagraphs are on 28. And you'll see there that various paragraphs of the intercreditor agreement are referred to, and we say that these provisions don't change the definition of enforcement action if it is suggested that they do, or impose any additional requirement, for example, as to lawfulness, which I think is being suggested. So looking at the particular provisions referred to, if we still have the intercreditor agreement open, supplemental bundle tab 9, looking at page 204, and we're looking for clause 1.5 of the intercreditor agreement. And it's the first of the three referred to by the appellant. This is obviously within clause 1, which is headed a number of pages back, definitions and interpretation. And clause 1.5 is subheaded fiducie. With respect to fiducie, the term enforcement, capital lowercase e, shall refer to any step or any action provided therein and taken following any trigger event, as set forth in the fiducie agreement. This is just pointing out that steps to enforce under the fiducie take place after an event of default and a notification, and only then when there's a triggering event, as set forth in the fiducie, and I've already shown you that set of provisions. It is not implying that the meaning of enforcement action, capital E, capital A, should be somehow different when applied to the fiducie. If it was suggested that to single out just one transaction security of the package and provide some different test which requires a higher standard of lawfulness or whatever, that wouldn't be a rational thing for the parties to have done, and there's no indication that that's what they did. And indeed, some parts of the definition of enforcement action, which I just showed you, don't use the word lowercase enforcement at all. Then the other clauses referred to are on page 224 of the same document. Clauses 10.1 and 10.2 of the intercreditor agreement. I've taken you here already, but I'll just show you them again because they're used in the context of an argument by the appellant. 10.1 contains provisions, as we can see from the heading, on enforcement instructions for transaction security, and 10.2 contains provisions on the manner of enforcement. And neither of them, in my submission, tell us anything meaningful about the definition of enforcement action within the intercreditor. If the parties to the intercreditor wanted to cross-refer to clause 10, they would have included it in the definition. And we say they're quite good at using definitions and cross-referring between agreements and within agreements. The judge pointed out at paragraph 74 that if the obligation to cooperate was subject to the bondholder having to prove, if necessary in court, that what it sought to do by way of capital E enforcement action was lawful, that would deprive the clause of much of its commercial effect. And I invite you to reach the same conclusion. He drew a realistic distinction in construing the language found in clause 5A, that the bondholder, and we see this in paragraph 75, the bondholder or agent's conduct, which is fraudulent or dishonest, can be challenged. Agents or bondholders' conduct, which is manifestly not even enforcement action as defined, can be challenged. What can't be challenged is purported enforcement action, which might be invalid formally, or a breach of a term of the finance documents, or unlawful in some other respect. And he made that point in paragraph 76. It suggested that in order to reach that conclusion, he would need some kind of authority. But in my submission, that's not so. By reference to the provisions on exclusion clauses, by analogy, it's natural to read this provision as excluding a possible challenge based on fraud or dishonesty, and the parties entering into the contract can be expected to have regard to that well-known principle in agreeing this language. If something is manifestly not enforcement action, then the clause isn't even engaged on any view. If it's purported enforcement action, then it's captured. Because if it were possible to challenge the alleged formality or lawfulness of any purported enforcement action, there would be no point in having agreed the clause in the first place. The fourth topic is the meaning of the phrase "at any time." The appellant skeleton, paragraph 22, argues that in the phrase "any enforcement action they may wish to take at any time," they is the bondholder and the agent, the words "may wish to take" indicate that the relevant cooperation is forward-looking. That's the argument being made. And the appellant argues that Clause 5A only imposes an obligation on the appellant to cooperate with enforcement steps not yet taken. If an enforcement step has already been taken, then the appellant is entitled to challenge its lawfulness. That is the argument that has been made. The judge rightly dismissed this argument at paragraphs 69 and 70.
Had any enforcement steps been taken at the time?
No.
So where does this point go?
Well, it is suggesting that if in due course the bondholder or agent tells in advance the appellant that it's planning to take some enforcement step,
You've got to
at
wait and
that
let them
point
do
it engages the duty to cooperate. But if they just do it, which is what you would expect to happen, they don't have any duty at all.
But it is forward-looking. It depends on what the baseline is for the forward-looking. If it's the baseline is the date of the additional agreement, it's looking towards enforcement action which the bondholder or the agent may take after the date of the agreement, as opposed to inchoate enforcement agreement, which might take place at some point. And it makes very little sense to say that you can't challenge enforcement action before it happens, when at that point no harm has been done, but you've got to wait until the harm has been done and then you can try and undo it all, which seems to me to be a very odd thing to agree.
Well, my lord, the argument is not being suggested that it takes from the date of the additional agreement. It's being suggested that the duty to cooperate at some future moment.
That's what I'm saying. It doesn't sound. Seems odd to me.
Yeah, well, the judge said, "I unhesitatingly reject that argument," and I invite you to do the same.
Yeah.
He found there was nothing in the clause to restrict it to collaboration before the action has been taken. It doesn't make commercial sense. He said that the effect of the argument was to restrict the duty of cooperation with preparatory steps prior to enforcement. And the clause makes clear that preparatory steps are actually included within the obligation, but are not limited to that. Moving on to the fifth topic, the commercial effect. What was the appellant giving up? Now, the starting point is to focus on the context. The clear words principle, if I can capture it in that way, invites consideration of the value of what is being given up, to see how clearly it would have to be spelled out. And the appellant skeleton, paragraph 21, gives two examples of potential challenges which it would be giving up the right to make if the judge's construction is correct. And the appellant effectively says the right to make these challenges is so valuable that they wouldn't be given up without more specific language than you see in this provision. And I understand that that point is still taken unless it's suggested otherwise.
My point is much broader. My point is that you wouldn't give up any right to challenge illegality, not just these two examples. These are just examples that Mr Craig put forward.
Well, these are the only two examples that have been given of cases where it couldn't possibly be expected, and it may be helpful to engage with a practical example just to test out the theory. So I will make submissions, although I acknowledge my learned friend's point seeks to go more broadly. Before looking at the two examples, there are two important points of context, though. First, what was the appellant getting in exchange for giving up these rights? And secondly, what was the commercial value of rights which the appellant admits it was giving up? As to what the appellant was getting in exchange in this bargain, the judge was very alive to the bargain made by the parties. The appellant, as I've said, was in a perilous position on the 11th of November. In the judgment at paragraph 73, it records that an invented fault was admitted, rights to enforce had accrued. The appellant was accepting in clause 4 that there would be a Luxembourg security enforcement event at the end of the standstill. And the judge concludes either the refinancing would be in place or the company and the parent were insolvent, and that was the end. What the appellant needed was time, and that the bondholder agreed to give it. but at a price that would facilitate its enforcement if refinancing failed. So what the appellant got in exchange was time, and without time, it was potentially game over. As to the value of what the appellant admits it was giving up by this clause, I just want to explain why that matters. If the appellant argues that clearer words would have been needed to give up some rights which are commercially low grade or unlikely to have arisen, but at the same time admits on its own case that it was giving up some incredibly valuable rights, then that casts doubt on the likelihood that the words used were insufficiently clear. And that is precisely the case here. On the appellant's case, at least until today, by clause 5, the appellant was giving up the right to challenge enforcement of the Luxembourg pledges. And I'm not sure whether my learned friend hadn't appreciated that was his case or if his case has changed, but if we could look, please, at his skeleton at paragraph 26, which is in the core bundle at page 31, tab 2. And this argument is being made in the context of submissions about clause 5D.
Give me the reference again.
Yes, my apologies. Core bundle, tab 2, page 31. We're looking at the appellant skeleton argument and we're focusing on paragraph 26. It's under the heading, which you can see from the previous page, clause 5D. And paragraph 26 says a further limitation on clause 5D is a temporal one. The relevant rights, i.e. given up by this clause, are those which exist or have accrued at the time that the additional agreement is concluded. And then if you turn over to paragraph 26b, it says the agent had other rights under the finance document at the time that the additional agreement was concluded. And the paragraph goes on to cite the right under clause A of the Luxembourg pledges to enforce the pledge immediately at his absolute discretion. Now, I'm going to come in a moment to that clause 5D argument and the accrued rights point, but for these purposes, it is admitting that one of the rights in its submission, which was given up, was the right to challenge the Luxembourg pledges, because it existed at that time. So that is the case that's in writing. And we disagree that that was an accrued right, but taking the appellant's case at face value, this is an admission that clause 5 meant that the appellant could not challenge enforcement of the Lux pledges. And indeed it has not done so. So it has acted entirely consistently with this admission, which repeats an admission made at trial. So today's submission is a bit of a surprise because it changes what we had understood to be the position. So in a world where on the 11th of November 2024, the appellant was giving up the right to challenge enforcement of the Lux pledges, if that's what's being said, that's the nuclear enforcement option, there would be no point in holding on to the right to challenge enforcement of other, frankly, inferior security. For the reasons I've already explained, once the Luxembourg pledges are enforced, the bondholder controls the parent and it controls the receivables owed by the parent, including those loans made by the appellant. It has indirect control of the company. The chances are, in reality, as at the 11th of November, the bondholder doesn't need to enforce the fiducie at all. It's only by coincidence or accident in unusual circumstances that is what has happened. Now, 2 examples are given by the appellant of rights which can't have been given up without clearer words, because it said they're so valuable, and they both arise in the context of enforcement of the fiducie. And the 2 key points in relation to both examples are the 2 examples arise in an inherently unlikely situation, having regard to the commercial realities of the time and the contract. And the 2 examples are, compared to what we had understood was admittedly given up, commercially low-grade rights. So the first example, if we could look please at my learned friend's skeleton or the appellant's skeleton at paragraph 21, which is core tab 2, page 28. The appellant is trying to argue, I think, in paragraph 21, trying to emphasise that as at the date of the additional agreement, the extent to which there were uncertainties as to the way enforcement would be done and the extent to which the bondholder might act outside the boundaries of the transaction documents to the detriment of the appellant. There was that potential. And on the judge's construction, the appellant wouldn't be able to do anything about it. And in that context, paragraph 21A gives an example which involves the following assumed facts. It assumes that there's been an event of default, which had in fact already happened by the 11th of November. It assumes that the bondholder decides to enforce the fiducie, which, as I've said, is unlikely if the Lux pledges have been enforced. The bondholder gives instructions for a notification of a triggering event. Then the trustee is required to appoint an expert to value the trust assets. And in that context, if all of those things have happened, then the bondholder, on this example, might give instructions to the trustee which interfere with the contractually agreed valuation process. So it's that last step which is the right to challenge that they're concerned about. If we could just look to see how that plays out within the documents. In the supplemental bundle, oh, I can just see the time, my lords.
Oh, that clock is a little bit
clock's wrong.
fast.
I've
so
got another
it's
4 minutes.
running about 5 minutes fast.
I'll keep going for a few more minutes. So
Yeah.
I thought I had overrun the lunch break. So supplemental bundle tab 8, page 156. We're in the fiducie agreement, again at clause 12.2. And 12.2a is headed valuation of assets. And it's a very long and complex provision, and the trustee alone is in charge of this process, not the bondholder and not the agent. And the trustee, from these set of provisions, has very specific instructions about how to go about the valuation of assets. And it's all given within this clause. The thing being valued is the trust assets, and that's referred to in little 1. And it's to be done in accordance with Article 12.2, and that's also within little 1. The trustee, as we can see from little 4, is procuring that the expert determine the actual and present value of all the trust assets, and the valuation date is identified in little 4. And even the method to be adopted by the valuer is prescribed in little 5. And if the trustee fails to comply with clause 12.2, obviously it's exposed to a risk of a claim, and the actions of the trustee aren't covered by clause 5 of the additional agreement. And the bit the appellant, I think, is worried about is in sub little 3 on page 157, so within this body of provisions. In order to get the third-party expert to do their job, you have to instruct them, you have to give them a letter of mandate. So it's the letter instructing the expert to do the job, agreeing payment terms, presumably, and so on. And that letter is to be negotiated by the trustee on the instructions of the agent, brackets, on the instruction of a simple majority. And that, in this context, is a reference to the bondholder. So the bondholder has very limited involvement in this process. It gives instructions to the agent, who instructs the trustee on the terms of the letter of the mandate. And the appellant is suggesting that the bondholder could insist that the letter of mandate instructs the expert to do something different to the appellant's detriment. And clause 5 would stop the appellant, from suing to complain about that. Now, in my submission, that overlooks the role of the trustee and its own independent obligations to follow the careful process laid out in this clause. And moreover, within this clause, one sees at 12.2 little 7 that the value of the assets as reported in the initial valuation report shall not be subject to challenge by any party, except in case of fraud or obvious error on the part of the expert. So the parties have been agreed to be bound by the outcome of this process. So there's limited scope for arguing about it in any event. So in my submission, this is a situation unlikely to arise, and the right to challenge the possible interference at that level in little 3 is a very low-grade commercial concern.
Right.
Milo, before moving on to the second example, that might be a convenient moment.
Yes. How much longer do you think you're going to be, suppose.
This second example is quite complex, actually. You may say, I don't need to go through it, but if you would like me to take you through it, I'm afraid it takes some complexity of stepping through the fiducie and the intercreditor agreement. You can see these are quite complex provisions. So I do need to spend a bit of time on that, subject to you saying, don't worry about it. And then I need to turn to clause 5D, which I can deal with more shortly. I have 5 points to make, but I've done the bulk of the work, as it were, in taking you through the material already. So I do need a little longer, I'm afraid.
Right. 2 o'clock.
All right, is able.